Our current law, SB 1451, is the Small Wireless Facilities Deployment Act. As it currently stands, HB 2379, which is an extension bill of SB 1451, does not protect the constituents of Illinois. There are no protective amendments. This bill is an initiative of telecom. It takes away local control. We went through SB 1451 line by line. We retained one of the top attorneys in the country who specializes in telecommunications and the federal law, the Telecommunications Act of 1996. He advised us how the language needs to change to give back local control to our municipalities so they can make the right choices for the residents of their community. We support the advancement of safe technology for both wired and wireless infrastructure and the restoration of local control. Back in 2017, when SB 1451 was introduced, many municipalities, counties, and organizations were not in favor of that law then and remain not in favor today. They have since learned how their local control was taken away. Their hands were tied. Local control should never have been taken away. There are many states that don't have a Small Wireless Facilities Deployment Act that are installing 5G. Chicago, who's exempt from our law, is installing 5G. There is no prohibition if we don't have this law. Not having this law allows you to take your power back by working with your municipalities to ensure all your constituents are connected without unnecessarily inundating your community with 4G, 5G equipment. The areas in Illinois that want or need 5G can still get it. Not everyone wants it. It is not a necessity. This law forces it upon us. 4G and 5G small wireless facilities will be installed in residential neighborhoods as well as business districts. We understand why a business district would want to have 4G and 5G. The best option is fiber optics as far as security, speed, energy, and safety are concerned. In the residential neighborhoods, we don't want to have a small wireless facility up to 65 feet tall every 2 to 10 homes on our front lawns or easements. Because 5G uses a higher frequency and it doesn't travel as far, it also needs 4G antennas for it to have coverage. So many more 4G antennas will be added as well. You need to have a very dense infrastructure in order for it to work. Are these small wireless facilities in the least intrusive location if they are where children play? An applicant can claim to the authority they suffer from a significant gap in their personal wireless services, and their proposed installation is the least intrusive means of remedying that gap. Wireless providers provide authorities with computer-generated propagation maps showing where there are gaps in coverage. Our attorney shared with us that 90% of these maps have been altered to serve the wireless provider's needs, not what is actually needed. Based on the federal law, the Telecommunications Act of 1996, an authority cannot prohibit service. They have to allow saturation so everybody has personal wireless services. However, they should use the least intrusive means. Because of what's on page 8 in our current law, SB 1451, an authority has to accept every one of these small wireless facility applications because the applicant does not have to provide any more information. The data necessary to prove the gap in coverage is not required by our state law. An authority cannot substantiate with evidence that there is no need without the data. Therefore, they cannot deny any application because it would be prohibiting service. It is important to require an independent radio frequency engineer to drive through the neighborhood, perform a drive test, recording hard and accurate data that states where there are drop calls and no service. So this is what the signage looks like on small wireless facilities. We found the phone number for Crown Castle on the caution label on the small wireless facility antenna on the right. We called and were told you have to keep back 5 feet from this antenna. That's what the label says. It's important to know this is an occupational standard set for workers that are up there for brief periods of time, not standards for the public. Who's measuring the levels to ensure our safety? Look at where they're putting these small wireless facilities. They're as close as 5 feet from residential homes. Now, if somebody was working on this pole, they might be within 5 feet for a few hours. What happens when you're at home 12 hours a day and this small wireless facility is only 5 feet from your living room, your kitchen, and especially your children's bedroom? What's the exposure like for them? We don't know. Once these are installed, no one takes readings on the levels of radio frequency microwave radiation emissions. We don't know if they're within FCC guidelines, which are 25 years outdated. No one is ensuring our safety. This bill does absolutely nothing to ensure our safety or the safety of all living things in Illinois. Here's a diagram representing the radiation pattern of a cell tower antenna. Look at the highest levels of radiation emitted from this antenna. Now compare that diagram to the photo in the right-hand corner. You can see this antenna is going to emit the highest amount of radiation right into that family room window or bedroom window where children are sleeping or playing. The microwave radiation may penetrate to every room in that building. You should have the right to defend yourself in your own home. That is not the case with our current law. Telecom tells you that 5G is a necessity and everyone wants it. Many legislators tell us, my constituents want this. But what really happens when a community comes home from work or wakes up one day to find wooden stakes on their front lawns without any notice? This photo from the Chicago Tribune shows the outrage of the homeowners in Hinsdale when it happened to them. Hinsdale residents started to ask what the stakes were for. When they discovered that Hinsdale had 143 proposed small wireless facility applications, they came together to stop it. Their local government told them their hands were tied because of law SB1451, which took away their local control. Residential neighborhoods should be given notice of application locations before approval. The community should be part of the decision-making process. HB2379 allows small wireless facilities to be placed on our private property. That can drop your property value by up to 20%, not to mention the fact that you're going to lose prospective buyers. Most people aren't going to consider purchasing the house with a small wireless facility on their front lawn. Verizon's plan is to make Western Springs, Hinsdale, and Clarendon Hills pilot communities for their 5G rollout. This is a pushpin map of only Verizon's small wireless facility proposed locations for these 3 communities. The blue pushpins on the right are for Western Springs. The red, green, and yellow pushpins on the left are for Clarendon Hills. The red pushpins in the middle are for Hinsdale, showing what it looks like when you have 143 small wireless facilities in a fairly small town of 4.6 square miles and 17,000 people. What's alarming here is that this is just the beginning. This is just Verizon. What about the other wireless carriers? How many more will Verizon want to install? This is where the definition of co-locate is really important. Co-locate should mean that wireless carriers use pre-existing poles that already have other wireless carriers' equipment on them, so they are co-located together. This is not how our current law defines co-locate. On page 2, it says you can install a new wireless support structure on or next to a wireless support structure or utility pole. In other words, you can install a new structure anywhere. Also on page 7, it says that if you do co-locate either in the rights-of-way or outside the rights-of-way, they are not subject to zoning review or approval. So the wireless carriers can put them anywhere and don't have to worry about the zoning review. In SB 1451 on page 5, the definition of a small wireless facility doesn't necessarily mean small. By the time you get through this entire definition, it includes macro towers. That's no longer small. It's misleading. The definition should be just small cells and DOS nodes, nothing else. On page 7, the wireless support structure is any structure that is capable of supporting the equipment. That opens the door to put them on just about anything. In the picture at the top of the slide, you can see some of the support structures these small wireless facilities are put on very close together on buildings, traffic lights, and light poles. Again, this would be in front of people's homes. It's also important to mention the fiber optic cables. If you look underneath the street, you will see the blue bar representing fiber optic cables. In many places, the fiber is already in place. Small wireless facilities and cell towers need fiber optic cable to work. If residential communities want 5G, they could choose the safe option to get it through fiber optic cable to their homes. Why would municipalities be against the law written by the telecom industry? This is a revised map from an application for small wireless facilities from Farragut, Tennessee. The blue rectangles represent 40 locations for small wireless facilities that the city received in just one application. The authority didn't have one application to review, they had a batch of 40 at one time. In our law, the applicant can submit up to 25 small wireless facility locations in one application. This is an unnecessary burden on the local government, as they have the same amount of time to review one location or all 25 locations. The equipment doesn't have to be identical, and each location needs a separate review. The local government may also have to spend a lot of money to hire additional attorneys, engineers, and staff to be able to review the batch applications. In SB 1451 on page 19, it says 25 small wireless facility locations can be on one application. On page 15, it says that the authority only has 30 days to review that batch of 25 locations on the application to decide if it's complete and to notify the applicant. If they miss the 30-day deadline, they can't ask for more information after that. Not only that, there's no room for error. On page 16, it talks about the fact that if the small wireless facility is going to co-locate on an existing utility pole or wireless support structure, the authority has 90 days to determine if the application is complete. If the authority doesn't make that deadline, it's automatically deemed approved. On page 17, it says if it's going to be a new utility pole, they have 120 days to determine if the application is complete. If they don't make their determination in that amount of time, it's also automatically deemed approved. On page 21, it says the fee for the first application that comes in is up to $650. Here's how the wireless industry gets a bargain, and the authority makes a lot less money for a lot more work. When more locations for small wireless facilities are listed in one application, the applicant only has to pay $350 for each additional location. In SB 1451 on page 5, based on this definition of right-of-way, the small wireless facility can go on the easement on your private property. The right-of-way should specifically say that it cannot be put on private property. All homeowners have easements on their private property. If you have electric wires, pipes for gas, or pipes for water, then a small wireless facility can be placed on that easement on your private property. Here are the top 15 reasons to vote no on HB 2379, the extension bill of SB 1451. This information has been posted on our website and sent to all the senators and representatives in the state, along with the IML and other officials. This information was obtained through a partnership with an expert attorney who specializes in telecommunications. These points accentuate the most misleading and detrimental parts of SB 1451 and HB 2379 when it comes to taking away local control. We've repeatedly asked for a seat at the table to negotiate this issue, but to no avail. With the counsel of our attorney, we've gone through every line of HB 2379, the extension bill of our current law. We have a clear understanding of the numerous restrictions this law imposes that take away local control and keep local officials from protecting their constituents. Here are some key points regarding HB 2379. Voting no on HB 2379 will not stop the advancement of wireless technology in your district. Municipalities will still be able to work with telecom to deploy the necessary 4G, 5G equipment to allow full connectivity without inundating and unnecessarily forcing hundreds of wireless facilities on communities where it is not needed. Illinois residents do not want to come home to find a cell tower up to 65 feet tall in front of their home or on their property easement. Local control must be restored. Our municipalities need to be able to work with telecom to find the least intrusive place for these small wireless facilities, while still allowing all residents access to personal wireless services based on the actual needs and gaps in coverage for each community. 5G wireless service is not replacing 4G wireless service. Even more 4G infrastructure needs to be added because 5G will not work without the support of 4G. In closing, it's clear that SB 1451 and HB 2379 are telecom initiatives, which is evident by the lack of protective provisions for Illinois municipalities and residents. SB 1451 and HB 2379 do not serve the people of Illinois or local governments and will continue to force wireless infrastructure into residential areas without any protective provisions. Illinoisans have the right to the quiet enjoyment of our homes and streets. Give the power back to the local governments and the people, as it should never have been taken away. Please do the right thing. Vote no on HB 2379 and any other replacement legislation that puts restrictions on local control. And let the current statute sunset on June 1st so that local control can be restored. Thank you for your attention and taking the time to listen to this presentation.